Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, England. Now I'm looking at a very interesting, very detailed book on the sources of European Union law and their relationships, with the subtitle Lessons for the Field of Taxation, covering primary law, secondary law, fundamental freedoms and state aid rules. The book has been written by Rita Szudoczky, and I hope I pronounced her name correctly. It's part of a thesis. It's published by IBFD in their Doctoral Series, volume 32, and it's obviously at a very high level in terms of its content and what it is trying to put forward to the readers of this particular book. Now, my wife Elizabeth and I had a good discussion about this book to work out how we would review it, because it's not one of the more easy books to review because of the nature of the content and what it's talking about, the sources of EU law and so forth. We came up with a title for our review of A Thorough and Rigorous Approach to the Study of EU Law with a focus on taxation, because we are looking at taxation. It's a hardback book. There it is. You won't find it on all the websites. There's the spine, and there is the detail of it in there. You won't find it necessarily on all the websites. This explains on the dust sheet, the inner cover, front cover. That is the statement about this series of books. And then there's a nice picture of Rita. There we go, give her a bit of publicity at the back there, explaining who she is. Got her PhD from the Amsterdam Centre for Tax Law. Now, the book itself is quite a heavy book. It's nearly 800 pages. The way that they structure books on the continent and in America sometimes is they have the tables of cases at the back. We tend to have them in the front in our English law, English legal system books. Then there's a bibliography just before the cases right at the back. Then what you've got is conclusions in the final chapter, chapter 11. There's been a huge amount of effort put into this. As I say, the actual work itself, 732 pages just for the chapters, probably an expansion of what was the doctoral thesis. But as I say, there are other titles listed in the doctoral thesis series right at the back. There is no index, which in many ways is unfortunate, because I think an index is also quite useful, but you could get someone to do that if the book comes out in another edition. Now at the front, because this is an important book, no doubt about it, you can see it was submitted to the University of Amsterdam as the thesis, and the degree was awarded on the 26th of November 2013, and she's dedicated it to her parents and Roger. It's always nice to mention the dedications. Then there's a forward and then a list of the various chapters there. You can see we've got chapter numbers and sub-number paragraphing, which is helpful. This is a detailed table of contents. You can see going all the way through chapter 8. Then we're going up a bit towards the end. And then finally chapter 11, the conclusions and the bibliography and the table of cases. Then there's a forward. This book contains my doctoral thesis. The book discusses case law and other legal developments up to June 2013. And then she's explaining a little bit about how it came about and thanking a lot of people. There's a short list of abbreviations, which again is always helpful, especially when we're dealing with EU law, because sometimes it's a little bit difficult to remember what some of the abbreviations actually mean. And I, like everybody else, get confused. There is chapter 1, the introduction. Then you see the paragraph numbering immediately, 1.1. That's research, question and relevance. Then you go straight in. And then you've got, as I say, you can see little footnotes there, all sorts of footnotes coming up. And then some other more detailed footnotes as we get into much more detail about what this book is about. The centre of the book, here we go, you've got, again, conclusions. I like the way that this is done. I have to say that I think it's always very important to have a bit of cross-referencing from other chapters, for instance, but it's also very useful to have a nice series of conclusions so that you round the subject off. So what you've got right at the end is the conclusion. The mission of this thesis was defined in the introduction as providing a systematic analysis of the relationship of the various sources of EU law with the aim of promoting a more theoretical and conceptual approach to the problems which arise from the interactions. And it goes on to say various other things. It's a lot of words, but it's a high level of argument, and bearing in mind it's a doctoral thesis, you know what you're going to get with them. So have no illusions before you read it. But let's get our feet down on the ground a little bit and let me explain what I think this book is really about. Because I thought it was a very interesting, we said it was a thorough and rigorous approach to study of EU law on basically taxation, an important, a very fundamental area of what the member states get up to, and part and parcel of what the arguments are about in this country from the independence parties. I'm recording this during the general election campaign 2015 in UK. I'm well aware of what the issues are both here and in Europe, and I think therefore this book is timely because we need to get some clear understanding of where we are. This is what we say if you're a tax expert, whether lawyer, academic or accountant, or aspire to be one. This book, which features a refreshing as well as scholarly approach to the taxation aspects of European Union law, should help you enhance your expertise. I have to say that EU law and taxation does very directly affect us in the United Kingdom, which is one of the reasons why the United Kingdom Independence Party has tended to get quite a lot of support in terms of party political issues. Now, the fact of the matter is that we need to recognise that. So what value does this book have? Well, it's published by IBFD, of which we'll be hearing, we think, quite a lot more in the future. And it's one of their latest volumes in the doctoral series, which I've indicated. There's a list right at the back. In line with the declared mission of this distinguished publishing house, which has dedicated itself to disseminating knowledge of international taxation and also promoting the study of taxation in general. And we welcome that. We have our own publications like Claritax, Tollies and the other big tax publishers, Spirimus, here in the UK. And this, I think, is an excellent addition because tax is with us and we have to know what we can and what we can't do. This particular and very rigorous examination of the complexities of European Union tax law is, as I've indicated, the doctoral thesis of the author Rita Szudoczky, written at the Amsterdam Centre for Tax Law at the University of Amsterdam, following her introduction to, in her words, quote, the fascinating world of international and European tax law at the International Tax Centre in Leiden. Clearly the author's EU orientation, as well as her obvious expertise in and enthusiasm for this highly specialised subject, makes this book a valuable find for students and academics as well as tax lawyers. So you've got a reasonably good market of people interested in reading about it. The central question which this thesis seeks to address can be broken down into two parts. First, what rules and principles govern the relationships of the different sources of EU law? Second, how do these rules and principles need to be interpreted and applied in order to reflect and reinforce the constitutional character and system nature of EU law? So there you have it. That's the basic mission. One gathers that the author's insistence on taking a systematic approach to the examination of EU law as a whole has hitherto been lacking, due to for the most part, to a number of factors, one of which is that the EU is a supranational or federal organisation which has evolved from what started out as an economic union. That, jurisprudentially and from the point of view of political scientists, is where the problem lies, because clearly some do not want it to be federal, and that is a big issue for the United Kingdom and perhaps other countries. The focus of the book, therefore, is not just on abstractions and theories, but on the role of case law, the evolution of a legal system that has been developed principally in the court of justice. Cases, says the author, inspire the methodological imagination of juries, interesting point, and of course emerge as the basis of a legal system which, it is hoped, has been influenced to a large extent by the prevailing ethos of common law systems. We would like to think that, certainly in the United Kingdom, bearing in mind that Henry II effectively created a lot of our modern common law from Glanville onwards, and he was, of course, French. So do bear in mind that whilst we are English and we have a common law system, there's a lot of intertwining outside the common Roman law structure. Pointing out that e-law is rarely examined as a legal system, the author has presented a methodical approach to the subject, which we think is quite rare. International lawyers, whether tax specialists or not, will doubtless find that the views expressed and substantiated in this book will generate much food for thought, particularly among those concerned about the future of the EU. And that, as I say, is where we are at a bit of a crossroads, certainly in the United Kingdom, and I think also in some of the other continental countries where we've had recent elections. Certainly the book has made a worthy contribution to the growing body of analysis and commentary on the various aspects of EU law. Excuse me. The publication date is cited at the 23rd of August 2014. Let's have a look at the book again very quickly. It's a hardback, there we go, and that's the back of it. Nice blue cover. And let me just open it up right in the middle. This is on primary law and secondary law in the field of taxation. And you've got, she does do cross-referencing back to previous chapters, saying recollections from chapter 7, and then she reminds us what we've looked at before, and then goes forward. And she does that on a number of things. Derogation test is a very interesting area again. What constitutes the benchmark system? Now, for people not quite familiar with this, I'm not going to go into detail, but you will know what derogation means, and therefore the test is set out page 494, which I think is quite helpful. There's a lot on that in chapter 9, and then going right to the back. As I say, the conclusions I think very, very helpful, because it, you know, where you're going to, if you're going to embark on an adventure like this, you want to have a clear aim of what you want to do. Let me just conclude. As the scope of the fundamental freedoms is too narrow to cover all aspects, various measures she's talking about, the more general state aid rules that should be applied, which offer remedies to all disadvantaged competitors, and therefore cover all aspects of the measure. And that's looking specifically at, effectively at fundamental freedoms, because she gets at the end of the conclusions really to part of the point, which is about the overlap between fundamental freedoms and state aid rules. And that, of course, is again a big issue, which we may well be facing in this country after the general election, if we actually have a referendum of some sort about membership of the EU, because all of these issues are going to come out again. I would like to thank Rita and the IBFD for what I found fascinating. It's not everybody's cup of tea, because it's very boring to a lot of people. It wasn't to me, because this is very fundamental to our relationship with our colleagues on the European continent, and certainly the way that we are going to be looking at the way we tax people and the way we deal with the legal aspects for the foreseeable future. So thank you, very good luck for the future. This has been a great contribution as a doctoral thesis. Good luck, and thank you to all concerned for producing it. Bye-bye.